Welcome back to the 6th annual Intermountain Construction Defect and Dispute Resolution Conference. We're so pleased to have you with us and participating in this rather strange, non-standard way of presenting a conference. The sessions for this conference are being recorded and have been approved by the Utah Bar Association for self-study. And so whether you put in for the CLE credits now or later, that's up to you. Today I have the privilege of participating and talking about construction defect resolution templates. A year ago, actually it was in May of last year, I had the privilege of putting on this same basic presentation with attorney Robert Franco in Chicago. The setting was a beautiful setting. It was the Loyola University's law school in downtown Chicago. A beautiful, beautiful venue. Most of the things that we will be talking about come from a collaborative effort with Robert Franco, and it is my goal today to talk about the following things. How do defect claims arise? Claims issues identification and triage, experts, leadership role that you might have, litigation, discovery, deposition, trials, and I've got a couple of handouts for you at the end if you are so interested. With an understanding of where the claim comes from, will give you the benefit of knowing how best to attack or work on the project. So we're going to do just a quick review of some of those particular ways claims arise. They come from annual reviews of buildings. These are for commercial. We're going to break it down into a couple of different categories, but the first one is commercial. They come from annual building reviews. They come from leaks and insurable named perils. And they also come directly from building engineers who have responsibility over the buildings. Residential defects mainly come from homeowner complaints, and as noted in a recent case that I've been working on the last couple of days, failure to disclose during the sale of a property. If you're involved with homeowners associations, often the complaints arise from lack of maintenance and principally when water comes into the property. There are often some defects that are also noted and attributed back to the builder in an HOA situation when they turn over the association keys to the actual association. In industry, defect claims normally come from throughputs and capacity versus output, or non-conformance where something went wrong, or based on life cycle schedules that are not being fulfilled. Institutional defects claims come from all of the above. They touch on all aspects of it. By the way, during my particular presentation, if you want to unmute your button and ask questions, please feel free to do so. And Jeff, if you'll watch the chats and notify me and let me know that there's something in that direction, that would be helpful. Once we have a claim, or we learn of a defect, we then go into the process of a notice of the claim, and we start to do our triage as we identify the issues. We're going to talk a little bit more later about the early involvement of experts in the construction. Often, as experienced personally, we get involved as experts late in the game, sometimes even after discovery has expired. When you get early involvement from an expert, they'll be able to take a look at the situation, help you identify the issue, and allows you then to give proper notice and tenders, help in the direct discovery process. And you want to make sure that in this particular process, you lock up your experts early. It is not unusual for our company to receive a phone call asking, are you on this particular case? And in many situations, when the request is late in the game, we are already on the case. It is a strategy, and it's something that I think is important to get a list of the subcontractors and involve everybody in the design and construction process and their insurers. There's a lot of interplay between the construction and design, RFIs that go between. I'm involved in a case that is down in Arizona that has a dollar value of about $88 million. And a lot of the problems have arisen because of the lack of communication between the construction people on the site and the design professional, and the failure of the RFIs to deliver what really needs to be done. As part of the claim triage, you want to get the final schedule and look at it for the statute in terms of the statute of limitation and the statute of repose. Larger projects will often have project manuals. It's very helpful for the expert to be privy and have access to that project manual. Along with the triage, you want to identify the scope of the various participants, who's doing what in the project, and at what stage they are involved in the project. There are generally insurance issues associated with it. And we then move to the settlement or litigation. In-kind settlements, you settle the scope. You want to settle on the scope and not necessarily on the parties. Non-litigation discovery includes obtaining documents through the Freedom of Information Act. Establishing a plan with your experts, a guide for the discovery, and will provide an early evaluation. What kind of experts do you need? And of course, in the construction industries, there's a whole discipline of different people that you may want to involve. Maybe it's somebody that is actually a hands-on type of contractor. Sometimes it might be a safety related person, somebody who is privy to standards and practices for that discipline. And of course, there's a multitude of different types of engineers, along with architects, and one of the more intense and difficult aspects of some of the large cases that we've been on have been the construction cost accounting aspect of it. Have they been paid more than they should have been paid? Have all the bills been paid? Are there liens outstanding? And who's responsible for what? Would like to ask some questions now, and there's a series of questions we're going to ask. And for the first couple, I want you to just think about your own personal response to this. When do you most often engage the service of an expert? During the past month, I've been asked to go do 2 site visits with a firm that was given the assignment Friday before the Tuesday site inspection was called. It really is best if you can involve the expert earlier than later. But we see that there's some people who have a practice of inviting the expert or asking for the expert's help immediately before the designation deadline. Some people also do it after you feel comfortable, you know where the case is going. I would make the argument that the earlier you can involve the expert, the better you will do on the case. It is not unlikely, let me rephrase that, it is very likely that if you engage the expert early, invite the expert to see the problem, they can give you some good counsel on where the problem lies and what your liability associated with it might be. Moving on to question number 2. At what point of time in the case does it make the most sense to you to know your strengths and weaknesses and understand where you stand? I would invite some responses on that. if you're willing to participate. When does it make most sense to you to know your strengths and weaknesses?
This is Glenn. From my perspective, as early as you can. You're going to discover strengths and weaknesses throughout the litigation, but you know, it always is. You can always overcome weaknesses with time. You can always direct a case to maximize your strengths, and so why not do that early? You know, the one thing about construction cases is that they require experts, and the good experts cost money. And I certainly understand a hesitancy to hire an expert until you know which way the case is going. But, you know, at a certain point in time, you know pretty well that this case is going to have legs or not, going to have exposure or not. And my suggestion, my practice is to hire early and get as much input as you can.
Thank you very much, Glenn. Anyone else want to comment?
Yeah. This is Greg. I am not embarrassed to tell my clients at all that the selection of their expert is more important than the selection of their lawyer. I mean, I can help them through the legal process and the theories, but the expert's going to tell me what kind of case these people have. And you cannot make a decision on where you're going to take the case if you don't get some kind of indication early on from your expert about where you stand. The other thing is that experts are not perfect, and you may find out that you have the wrong one. And you want to, if you find out that you have the wrong expert, you'd like to find that out early enough that you can make a change without it being a disaster.
Very good points, Greg. Thank you very much. Anyone else want to comment on this? Let's move on to another question then. Considering the last time you used an expert, was the expert encouraged to ask questions from a different perspective or point of view? Thoughts?
Well, this is Glenn again. Certainly, I think there is a value to having the expert let you know what to expect to hear from the other side. When I hire an expert, when I used to hire experts, I'd always want somebody who had been on the other side enough to know essentially what would be argued. And so I think having some questions, some other perspective is important. You know, the other thing is, you know, there's always this issue of when you're a lawyer and you're communicating with potential experts, you know, how discoverable are the questions and answers that you pose to your expert. At least in Montana, I think it's in federal courts too, they're getting away from the kind of full disclosure that they used to have, and allowing you to have some, you know, discussions and even document those discussions, and not necessarily have them exposed to discovery. And so it's helpful. I think that's good, because you want to be able to ask the questions, how can I lose this case? Is it a good case?
Thank you very much. It has been my experience that on an occasion or two, when I've been briefed on the case, it's been with a very biased point of view. And when I have the desire to ask to get a different perspective of it, I've been shut down. So I think it's very relevant and very important for you to encourage questions so that you know where you stand, and you aren't hiring a paid gun that is going to sing your song to your tune. Second part of this particular question, question number 3 is, have you ever had an expert who stimulated new thoughts, given clarity, or perhaps even caused you to think of new theories of law? Comments? I certainly hope that this is something that an expert can do in your behalf.
Yeah, Gene, this is Brian. Yeah, I've had that. I mean, obviously, you hire the expert to come in and analyze. You know, a lot of times it's on the rebuttal side of things, and then bring up new points and issues that they see through their experience, which can be very helpful to me in my practice and help and representing my clients. So I think working as a team is very important, and full disclosures between the expert and say, yeah, I've seen this before and it's very helpful, or I've seen them go this way and that's been problematic. And so working as a team is the way to go.
Thank you very much, Brian. One of the things that I would hope that you would not want to happen is to be ambushed with a thought or a situation that could have been brought to your attention by the expert. We occasionally do some work over in Oregon, and they don't do depositions over there. But when you're brought to trial, the questions that come are more like an ambush. It's deposition by ambush and not by reason or logic. So I do believe that it's important for the expert to be able to give you both sides of the story so that you know what you're facing, even though it may be contrary to the best interests of your particular client. I think that you need to know all sides, and if your expert is not giving you that, then you need to think again. And like Greg said, perhaps it's time to change.
Yeah, the best interest of my client is all knowledge. I mean, so blowing smoke up my client's skirt doesn't, or by me or my expert, that is not valuable.
Great, thank you very much. What and this is a very important one. What don't you want to share with your expert? And I will represent that there are some things that, as an expert, I don't want to know. Any thoughts? Come on, somebody help me out here.
I'm trying to think, Eugene, what I wouldn't want to share with you as an expert. You must have some idea, and I'm really curious what it is. You know, I think there are some, you know, there may be a variety of issues. You know, a couple of things come to mind just from experience. There may be a situation where you've got one subcontractor who's got questionable insurance and another who's got the insurance. And so the question is, are you going to share the scope of work versus the two? That's a judgment call. I mean, obviously, you'd be better off if the one that has coverage is all the liability goes to them. But maybe that's not something you want your expert to have, you know, grounds for possibly being impeached. But I'm just curious, Eugene, what are you thinking of here?
And maybe I'll throw one other thing out there, and I'm not sure if this is what you're looking for, Gene, as well. Is I've had one where it was more of a rebuttal expert in an accounting scenario, and and so it was as to costs that were incurred and what was reasonable and whatnot. And so what I hired him to do was more or less to just say that report sucked, rather than having him do his own analysis as to what the damages might be, because I didn't want the opposing party to then somehow say, well, your expert did the analysis and said it should be this. And so, and they actually, when they deposed my expert, they tried to do that. And he said, don't know, didn't analyze it. Not part of my report. That's not what I'm doing. So I don't know if that's, so that would.
And that's along the lines of what I've been thinking about, Brian. Thank you. When you hire your experts, you generally do it with specific things in mind. You want that particular person to do a specific task, but often because of that person's expertise on the stand, they are sometimes asked, well, what do you think about this, or what do you think about that? And it may not be in your best interest if you've already been, that this may be a weakness of your particular client. You don't want your expert to testify against your client. So sometimes you need to withhold the information that is going to be discoverable or could be discoverable through testimony. Let's go to the next one. And this is just a sort of a generic type of question. What are the different types of experts that you have personally used? Think back, and hopefully this will stimulate a little bit of thought. Sometimes you, like Greg said earlier, he may have hired the wrong particular expert. You may have wanted somebody who could talk about standards and practices, or you may have wanted somebody who can give you dollar figures and expertise on the costs. But there's so many different types of experts out there that it is sometimes a little bit confusing, and we often think that, oh, all we have to do is just call this one person and he can take care of all of it, when that's not necessarily the case. You may have more success with somebody who has the specific construction background than when you have somebody who is a generalist. This is one of my favorite questions. When do experts look like fools? Your thoughts?
Well, when they happen to
And I may be guilty of some of these things too.
I think it's always easy for an expert to overreach, to get into issues that they've been not been asked to provide opinions on, and therefore they may not have seen everything they need to see to form an opinion. That's the circumstances where I've encountered that.
Exactly. Go ahead. I didn't see who was trying to come in. Have you ever been embarrassed by your expert?
I can share one thing. It was a long time ago, but my father, may he rest in peace since he's long since passed, but he was an expert in one of our cases, and the opposing counsel in his closing argument said that Mr. Babcock, which was my father, the expert, has harpooned us with our own documents. And so it was after that was a successful case, obviously, for us and our client, and our client gave my father a plaque with a harpoon on it, and with that statement, because again, they had hired their own expert who just, from our perspective, never got it, and so we hired, my father to be an expert. He's a civil engineer, and his analysis was much more on point, just using their own documents. And they finally got it during trial, that finally the light clicked on in their heads. It took, they just wouldn't listen, and it finally clicked on. And so your closing arguments become much easier when the opposing party or counsel gives your expert the credibility and undermines his own. So that was one where it looked very bad for the other side.
Thank you very much. I was involved in a trial down in Miami where I'm going head to head with an expert, and we actually got to the point where we were in trial. 3 judges had reclused themselves from this particular case because of the involvement of the Cuban mafia, and the expert that they hired came in and presented his particular case, looked like a fool, and the judge then indicated to the jury, I am directing a verdict that this case has no merit. So we don't want our experts to look like fools, and when we do, that was one of the 2 cases that I've been involved in that has been a directed verdict.
And let me throw one other thing out there just real quick, and this is no critique of you, Eugene, but you become a hired gun, and what do you want me to say? What do you want my expert opinion to be? And I think, as you talked earlier, it's important to be objective, and so you don't lose that credibility, because there are some experts out there that I see their reports and I just go, okay, I know what it's going to say, and I've been in mediations and different things and talking to mediators and say, well, such and such, they'll say whatever they need to say. But back to that same case that I was just talking about, where my father was the expert in that one, there was one of our other experts was a equipment operator who came almost, straight off the job. He's wearing his boots. He's got mud on him. He talks like the guy, and he had incredible credibility. So you have the one that comes in the 3-piece suit with all the PowerPoint presentations and all those things. Sometimes they come off as being too scripted and too good, that they don't have the credibility. So you have to find the happy medium between the 2.
Very good. Very good. Has anyone ever had an expert withdraw from one of your cases? Simple yes or no.
I had an expert withdraw because he died.
The ultimate withdrawal.
Very bad position.
We're going to talk a little bit later about how to preserve his testimony. Okay. Can you, if you feel comfortable, can you share any mistakes that you've made in the use of experts? Have you ever had an expert that has been impeached? The second part of the what major mistakes have you made in the use of experts would be, what would you do if you had to do it over again?
What comes to my mind, relates to the expansive soil cases I mentioned. And that is that for a while I was using simply a structural engineer, and there was a real need to get a geotechnical engineer on as well. And it doubled the cost, if not more than that. But, I think that the mistake was not to understand where one field ends and the other begins, and just what the literature tells you in terms of what is within their fields of expertise.
Thanks, Glenn. What I'm asking you to do now is just reflect and use past experiences to improve your use of experts. Thank you. When Bob Falco made this presentation, he spoke both to the defense and to the plaintiffs, and he said, here are some things that I see that each side needs to do. And I've summed it up into just really easy sentence here. The defense, the most important thing that the defense is to have someone take a leadership role. Yeah, particularly if we're bringing everybody into the case. Somebody needs to take a leadership role and help create an appropriate plan of action. On the plaintiff side, the plaintiff's attorneys have really a big responsibility of driving a wedge between the different disciplines, breaking it up, because it's easier to get something to happen when there's not unity among the defense. Bob then talked a little bit about the reluctant litigator and the problems of handling. He said personal injury attorneys who do construction cases often do not understand the importance of speed and time. They put things off. They think that the longer they wait, the better it is. There's often an action where the plaintiff is moving the case to mediation. I have a case going right now where the plaintiff in this particular case is acting as a home builder up in Park City, and he is a disbarred California attorney living in Beverly Hills. And I believe that it appears to me that he's a pretty good shakedown artist, because what he's trying to do is he makes allegations but does not provide the discovery documentation that's being asked for, but is pushing heavily to move the case to mediation. And most of the people involved look at it and say, well, this is probably a good thing for to do. Let's get into mediation, because that will lessen the cost of litigation. But this guy is playing on playing and planning on people making what he would consider to be the best business decision and come up with a quick settlement no matter what it happens to be. So he moved very quickly to mediation. He fits the next aspect of it too. He refuses to provide the discovery that is needed and seeks to move the claim very quickly. Again, be careful and don't let the litigation be driven by the coverage. Are you familiar with the Lone Pine Sedona motions as they relate to residential cases? Anybody? At the end, I'll provide, if you're interested, in a document, but basically the Lone Pine motion is something where they are moving to get all of the discovery information quickly and so that it can be relevant to the case and not piecemealing it out. Out of the gate, if it's an HOA situation, Bob suggested that you separate the individual units from the HOA because it's an easier battle. When you're doing depositions, get the person most knowledgeable to do the deposition, and that could be the HOA president. Focused discovery is important, and this is I guess a very important aspect of it, because we often don't focus as much as we should on the discovery aspect of it. He suggests that we subpoena everybody. We determine the relevant documents for the depository. And he talked about special problems regarding arbitration, which I think Glenn hit on also, very similar type of things. He indicated that arbitration at one point was a good solution, but it's becoming now very expensive, and it can also be challenged because arbitrators, if I'm remembering correctly from his presentation, have a tendency to allow things in at the last minute for fear that their decisions may be overturned because they haven't considered all of the documents. Let's talk about paper or electronic. Electronic storage information now is crucial because we're in an electronic type of environment. However, again, this is the Sedona and the Lone Pine, thing that electronic documents can often be forged, and they don't have the same way of laying out a foundation. I've got a good draft of the July 2020 Sedona Lone Pine thing that at the end, if you would like a copy of it, I'd be happy to provide it. How do you authenticate the documents? And in one of the recent cases that I have been considering, we've been given probably 1,300 pages of text messages, emails, and documents that look like they're date stamped, but could have been forged and could be problematic. Let's see. When you are doing discovery, one of the things that I think is not used as often as it should be is the actual schedule. And there are a couple of wonderful scheduling programs like Primavera or Microsoft Project. I would venture to say that on commercial projects, there's generally a pretty decent and good schedule. On residential, often the contractor is shooting from the hip and doesn't really have a good schedule. You want to take into consideration the remediation efforts that have happened. You want to look at the maintenance schedules and the maintenance logs if they're available. The homeowner, in most cases, is bad at document management. And so they will gather up a bunch of things that may be good and may not be even relevant. The $88 million project case that I'm on has 30 plus attorneys, and it happens to be a case down in Prescott, Arizona. They do not have a courthouse, a courtroom in the courthouse that will even allow the 30 attorneys to attend and participate in. So it's being, it's really a nightmare, but one of the things that we've noticed is that the defense, and I'm representing a small subcontractor on this particular project who has minimal exposure, but what I'm finding is that the person who's taken the leadership role in the defense to keep the defense all uniform and together has created a hosted platform where they're sharing expenses, but they're also putting the documents in so that everybody has access to the same documents. And it is makes this a little bit easier for us to access and to gain the information that we need. It's very important to keep the person with the most knowledge as the person who has the most knowledge of the records and is custodian of the project, heavily involved in this. Here's a summation of the Lone Pine order, and I've just sort of encapsulated what I think is the effective portion of it. Federal and state courts are using Lone Pine orders to effectively manage and control mass tort cases and other complex litigation. A Lone Pine order is a case management order that requires all plaintiffs to furnish fundamental evidence to substantiate essential elements of their claims, such as causation and the nature and extent of the injuries or damages. Used strategically, a Lone Pine order provides defendants with a powerful weapon to streamline and narrow the claim or even eliminate them altogether. We do have some problems with depositions, and that's absentee witnesses. And we learned, heard today about the loss of an expert dying. What do you do? Well, we can do rely on video testimonies, or we can do the depositions via Zoom or in other ways, but somehow we've got to be able to preserve the particular information from your expert. Are there court limitations on the depositions that they'll allow? How do you personally preserve their testimony? Okay, back to a couple of questions. Bob Franco created a 25-point article for the Chicago Home Builders Association on how to prepare a person for deposition, and it also works really well for trial. I have his article that I can share with you if you are interested in it. What do you need to do personally to prepare somebody for deposition? And there's some people who do a marvelous job, and there's some people who say, well, you're the expert and I don't think I need to even talk to you about it. But let me give you one example where a little deposition preparation was helpful. I referred earlier to the Cuban Mafia case that I was involved with. This particular case involved a Hurricane Katrina, and it eventually involved Hurricane Wilma. Katrina came through the Miami area and ripped up roofs on 4 of the properties owned by the Cuban Mafia. They did Band-Aid patches on them. The adjuster who was in charge of looking at the damages paid them $2.5 million. Katrina was principally a windstorm that did damage. 2 months later, through the same path came Wilma, Wilma being principally a lot of water and moisture, and did water damage to the properties. After Wilma, the owners of these properties claimed damages. The adjuster came out and again wrote them another check for $2.5 million, which, by the way, was limits of the policy. So they ended up getting policy limits. They were not satisfied or happy with that, and they got a public adjuster involved, and the public adjuster bumped the claim up to $7.5 million and then later to $19 million. My particular role was to go through the public adjuster's estimate and find where the flaws were. In so doing, I found that they had put the same line items on page 20 as they did on page 120, as they did on page 320. And as a result, I was called into deposition for 5 hours, and then another 5 hours, and then another 5 hours, 3 times. During that last deposition, prior to walking in, I was briefed by the attorney as he prepared me for that last deposition. He said, today they're going to try and get you to say the fraud word. And in Florida, you are not a fraud expert. Therefore, please do not say the word fraud. Well, lo and behold, as we came to the end of the 3rd deposition, the attorney doing the cross-examination basically asked me, are you accusing my client of fraud? Thankful that the attorney, as we walked into the meeting, prepped me not to say the word, because he said, if you say it, all of your testimony will be thrown out. I knew that I shouldn't say the word fraud. And so what I did respond, and I said, sir, you must have forgotten that I come from Utah. And in Utah, we don't use the F word. It ended the deposition, and this ended up being the case where the judge directed the jury's verdict, and we prevailed and were successful in it. Preparation of your expert is prime and very, very important. Who benefits the most from the deposition. And in the interest of time, I would let you answer, but time is of the essence now. And I think that the person who benefits the most is the person who's asking the questions. We want to be truthful and give proper answers, but we don't want to give away all the cookies from the cookie jar. Think about the basic instructions that you give when you're preparing a person for deposition. I always like to have somebody preparing me say, tell the truth, so that when I'm asked, what did you discuss with the attorney prior, I can say, I was told to tell the truth. One of my biggest problems deals with hypothetical questions, because they can be twisted and they are gnarly and difficult, because they make me think that I'm not being responsive and not being able to answer properly. So prepare your witness for how to deal with hypothetical questions. There are some of you who prefer your witness to answer yes or no, and there's some who would prefer that you elaborate on your answers. Think about how best you can do damage control when your witness does some damage. Is it appropriate to take a break to conference with your witness? That's an ethical question I leave in your hands. Is it appropriate to coach your witness to work in points that strengthen your case and positions? I think in some cases, yes, it is, because I think you know what theories of law you're looking at and want to engage in, and they would be your strength, and so you want your witness to be aware of those. What is the importance of this deposition question? Do you have any other opinions that you plan to use at trial? Here in the state of Utah, the opposing party has the option of either selecting a written report or a deposition. If you can do a deposition and if you can ask this question, then you can pretty much eliminate any other extra things that might pop in at time of trial. We could talk more about trial, but time is of the essence. And one of them that I would suggest is, how do you make the evidence come alive? And I like Brian's analogy of harpooning. That was great. I think that at trial you can sometimes get electronic evidence dismissed because it doesn't have the proper foundation or background. Takeaways: spend your money early, identify the cases you can win, and settle the ones that you can't. Never have your client fix the work itself. Engage a third party with a specific scope. Fund the scope rather than taking control of the remedial work. These are commercial claims, not tort claims. Ensure you have a handle on the controlling documents. Defense: develop your team. Plaintiff: break up the team. Preparation is the difference between winning and losing. Those of you who do a good job of preparation win. Don't be afraid to try defect claims. The aggressive lawyers win. Discovery theory of the case with their leadership. I have two handouts if you would like. One of them is a copy of Robert Franco's 25-point guide to preparation of an expert. And the other is the latest Lone Peak Sedona electronic